Good morning, sir. Can I get your full name?
Yeah.
Thank you, Mr. Adame. This is a time set for your review hearing on your Maricopa County Superior Court warrant. What I see here is you've just recently been sentenced on your local matters with Judge McGinley. Is that right?
Yeah.
It was probation with some jail time? Okay, so what I saw was 90 days jail. So if you get that bed space early and probation tells you that they got that bed space, let your attorney know so that you could be in front of Judge McGinley sooner and tell him that 90 days should be cut shorter to what it is so that you can get released on that probation case. Because on the review hearing for the out-of-county warrant, to them, all they see is the 90 days and they're going to wait till that 90 days, even if you have that bed space available sooner. Okay? Does that make sense?
That's from Maricopa. That's correct.
Yeah, this is the Maricopa County case. So we're just making sure that everything locally has resolved. But to Maricopa, what they see is that 90 days, and they'll look at that as 90 days full, even though you can be released early once you get bed space. Maricopa will see that as 90 days, and so the jail will hold you for that full 90 days. So if you get bed space before that 90 days, let your attorney know to go see your sentencing judge again to cut back that 90 days to whenever you get that bed space. You know, if it's like 45 days, I have that bed space, tell your attorney so that you can go see the judge again and say, Judge, can you cut back the sentence so it's 45 days now so I can get released on this probation case? And then Maricopa County will figure out if they want to pick you up on this case.
Oh, okay.
Right?
Gotcha.
Yeah. So if you
Thank
get that bed space before 90 days, tell your attorney to go see your sentencing judge again so that you can get released on that probation case.
Thank you, Your Honor.
Sure, you're welcome.
Yep.
You're welcome. Hold on. I'm going to set a review hearing on October 13th at 9 a.m. So that will be past the 90 days. So hopefully everything would be resolved by then.
Okay.
All right.
Thank you.
You're welcome. You're excused for today.
Thank you.
Good morning, Your Honor. This is the Spanish interpreter on the line. According to my list, there's no Spanish speakers. Maybe we'll confirm with the jail, please.
Yes, at the jail, can we confirm there are no Spanish speakers today? Okay, thank you.
Thank you. May the interpreter be excused, Your Honor?
Yes, thank you, ma'am. Have a good day.
Thank you. You too. Interpreter will now disconnect.
All right, good morning, sir. Can I get your full name, please?
Jorge Tonava, 0819-2000.
Thank you, Mr. Tonava. This is a time set for your review hearing. I'm seeing you on the Cochise County Superior Court case warrant. Looks like you still have local charges pending with Pima County. I see you have a pretrial in about a month, end of August. Does that sound about right?
Yes, ma'am.
So this is just trailing along, sir, to make sure after all your local charges have completed. So we'll set the review hearing September 1st at 9 a.m. to see what's going on still with your local charges.
Okay. Thank you so much.
Thank you. Have a
Appreciate
good day, sir.
You too.
Your Honor, jail here, Mr. Rivera has refused to come to court today.
Where is it? I checked that box. Oh, sorry.
That's the original. So, best way to find that out. Well, I'm participating in that. That's included.
Morning, can I get your full name, please?
Sorry, so Iverson.
Good morning. This is the time set for initial appearance. I'm seeing today on some failures to appear at a Pima County Justice Court for criminal trespass. Also seeing you on a new misdemeanor out of Pima County Justice Court for criminal trespass. Those are both misdemeanors. And also seeing you on Tucson City Court, failure to appears for multiple counts of criminal trespass, direct paraphernalia. Right now, you have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. All right, on the justice court cases, because of the failures to appear, I am going to appoint you an attorney. It's going to be Amanda Bynum. I'll set a bond of $250. It'll be concurrent on both cases, cash or secured. Conditions are the same. Do not go to the incident location. Next court date, ma'am, will be tomorrow, July 24th at 1 p.m. So you'll see a judge tomorrow on that. And then on the Tucson City Court cases, again, for the failures to appear, I will oppose a bond of $500. It'll be cash or secured. If you do post the bond, if you're released, no drugs, no alcohol, do not return to any incident locations. Appoint you an attorney, Tucson City Public Defender. So you'll have attorneys on both your cases. Next court date for Tucson City is next Friday, August 1st at 1:45 p.m. So you'll have a judge, you'll see a judge tomorrow, have an attorney tomorrow, and you'll see a judge next week, and you'll have an attorney next week as well. As you can see, when you fail to appear for court, warrants can issue for your arrest. You understand all that, Ms. Iverson?
Yeah, I'd rather be released today. I'm probably trying to get released. I don't want to stay any longer for this.
I understand you don't want to stay any longer, ma'am, but you failed to appear for court multiple dates on multiple cases. So that's my decision. You could talk to a judge tomorrow about it, okay?
Chris?
Hmm?
Go.
Morning, ma'am. Can I get your full name, please?
Monica Madrid?
Middle name Lizette?
Yes.
Thank you. Ms. Madrid, this is the time set for your initial appearance. I'm seeing you today out of Pima County Justice Court for a new misdemeanor charge of assault, domestic violence. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one, one may be appointed for you. All right, ma'am. So do you have minor children with Mr. Heredia?
Yes.
Do you have a family case right now?
No.
No. All right. If I release you today, do you have somewhere you can stay that is not with him?
Oh, yes, I live by
You have a
myself.
shelter? Okay, all right.
Yeah.
All right, ma'am. So I'm going to release you today on your own promise to appear for your next court date. That's just a fancy way of saying you don't have to check in with anyone other than making sure you show up to court. Conditions include do not commit any acts of domestic violence, no contact with Mr. Manny Heredia unless it's communication regarding parenting of the child. All permitted communication should be free of threats, profanity, or attempts to reconcile. All right, and don't go to his house or work or anything like that unless it's, again, about the child and having to pick up, drop off, that sort of thing. All right, next court date, ma'am, will be August 4th at 10:30 a.m. at the Pima County Justice Court. When you get released from jail this morning, you'll get a sheet of paper with all the information. There'll be a phone number on there as well. If you can't make that date for some reason, you call them to reschedule. If you don't call them and you don't show up, a warrant can issue for your arrest. You understand all that, Ms. Madrid?
I do.
Thank you, ma'am. You're excused for today. Good morning, sir. Can I get your full name, please?
No, Vosber.
Thank you, Mr. Vosberg. This is the time set for your initial appearance. I'm seeing you today at a Pima County Justice Court for some new misdemeanor charges. There's theft, assault, domestic violence, unlawful imprisonment, and domestic violence. These are all misdemeanors. You have the right to remain silent, sir. Anything you say can and will be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one, one may be appointed for you. Right, so if I release you today, is there somewhere you can stay that is not with Camille?
Yeah.
Okay, where would you stay? Okay, you don't live with her? Okay, so I am going to release you on your own promise to appear for your next court date. That's just a fancy way of saying I'm releasing you out of jail today. You don't have to check in with anyone. Of course, you have to show up for your next court date, though. Do not commit acts of domestic violence, no contact with Miss Camille. Don't go to her house or her work or anything like that. All right, and let's see. Your next court dates will be August 4th at 10:30 a.m. at the Pima County Justice Court. When you get released.
4th.
Okay, well, Call the number and let them know. I don't know what time your summons is, but call them, let them know. If you're already at the courthouse, that's great, you know. But call them, let them know if you have to reschedule. But make sure you show up, okay? All right, thank you. You're excused for today.
Wilson.
Morning, can I get your full name, please?
Carolyn Wilson.
Thank you, Ms. Wilson. This is a time set for your initial appearance. I'm seeing you today on new misdemeanor charge from Pima County Justice Court for failure to apply with a court order alleged to be domestic violence. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm going to appoint Amanda Bynum to represent you. All right, so ma'am, looks like you're pending an Ajo Justice Court case right now with Mr. Hodges as a listed victim. You also have an active order of protection where he is the listed protected person. So I am going to hold you with a bond today. It's going to be $100, cash or secured. If you do post that bond, ma'am, or if you're released, conditions include do not commit acts of domestic violence, absolutely no contact with Mr. Hodges. There is an active order of protection, ma'am. You can contest that if you choose, but that's separate, okay? So while it's
I filed an order of protection against him as well. It hasn't been served.
okay.
I am wondering, like, if I am able to get released, if I'm able to have this transferred to another state where I have more resources and a place to stay.
You can't transfer a criminal case to another jurisdiction. Perhaps probation can be transferred, but not the actual case itself. Okay.
Okay.
All right. So no contact with Mr. Hodges. Don't go to find him or anything like that. All terms of the active order of protection. Next court date, ma'am, is actually tomorrow, July 24th at 1 p.m. So you'll see a judge tomorrow. You'll have your attorney there as well.
Okay.
All right. If you fail to appear for court, whether it's tomorrow or future date, a warrant can issue for your arrest. You understand all that, Ms. Wilson?
Yes, ma'am.
Great, thank you. Your excuse for today, ma'am.
Mr. Barrera.
All right, good morning, sir. Can I get your full name, please?
Pedro Reverse.
Thank you, Mr. Barreras. This is the time set for your initial appearance. I'm seeing you today out of Tucson City Court for a new misdemeanor charge. It is for disorderly conduct, domestic violence, which is a misdemeanor. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one, one may be appointed for you. All right, sir. So if I release you today, do you have somewhere you can stay that is not with Desiree?
Yes, ma'am.
You have a separate house from her?
That's my own place that I have. But she can have, she has a father that lives near next door.
Okay,
and
but you
there's
have
a
somewhere you can stay
apartment.
that's not with her?
Yes,
And where is that?
there's 40 East Adams Street.
Okay. All right, so I'm going to release you today on your own promise to appear for your next court date. That's just a fancy way of saying you're getting released from jail today. You don't have to check in with anyone other than making sure you show up to your next court date. Do not commit
Yes.
acts of domestic violence, sir. No contact with Miss Brown. Don't go to her house or anything like that. All right, Mr. Barreras, your next court date is August 26th at 1:30 p.m. That's about a month from today. Get released from jail today, you'll get a sheet of paper with all the information. If you fail to appear for that court date, sir, or a future date, a warrant can issue for your arrest. So it's very important you show up or you call them to reschedule if you can't show up. A trial can go without you, sir. If you're convicted in a trial with in your absence and not able to be sentenced within 90 days due to warrant status, you may lose your right to a direct appeal. Do you understand
Yes,
that
ma'am.
this is a felony to show to court, Mr. Barreras?
Yes, ma'am.
Thank you, sir. Your excuse for today.
Thank you.
Mr. Barrett. Let's see right there. Okay.
All right, good morning, sir. Can I get your full name, please?
Good morning, Judge. My name is Patrick George John Barrett. I see the man in North Dakota where I was born.
All right, thank you, Mr. Barrett. This is the time set for your initial appearance. I'm seeing today on some new misdemeanor charges out of Tucson City Court. Charges are for assault, criminal trespass, and possession of drug paraphernalia. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one, one may be appointed for you. Sir, it looks like you're pending a number of different cases out of city court right now. I see 9 separate other cases right now. It's sort of consolidating them with this case. That just means everything is together. You'll have one court date. It's sort of
Yeah.
between the other court date you have right now. Because you're pending so many cases right now and you've been arrested on additional charges, I am going to hold you on a bond, sir. It's going to be $100 cash or secured. If you do post,
No.
it's going to be $100 cash or secured, sir. I'm going to appoint you an attorney, the Tucson City Public Defender's Office, so you'll have an attorney. If you do post that
Yeah.
bond, if you get released, no drugs, no alcohol, no contact with any alleged victims, don't return to any incident locations that you've been trespassed from. Next court
Okay,
date,
that's
sir,
right.
will be August 1st. That's next Friday. That's about a week and a half from now at 1:45 p.m. If you're still in custody, you'll be seen by video. If you're out of custody by then, it's up to you to make sure you show up to court. If
Oh,
you
yes,
don't-
ma'am.
All right, if you don't show up to court, sir, a warrant can issue for your arrest. Trial can go without you. If you're convicted at a trial in your absence but not able to be sentenced within 90 days due to warrant status, you may lose your right to a direct appeal. So it's in your best interest to
Okay.
cooperate with your attorney. Make sure you show up to court. You understand all that, Mr.
Yeah.
Barrett?
Yes, I do, yeah.
All right, thank you.
I do plan most of it. But I'm not sure where I go to a location for my hearing to prepare for pay my, my next viewpoint court hearing. I'm not court anymore to pay my dues, my $100 fine.
Okay, I'm holding you on a
I'm not
$100
sure.
bond, sir. You'll see a judge next week.
On next week downtown, say, or this location.
You'll be seen at Tucson City Court.
Okay, yes, Your Honor. Thank you.
Thank you. Morning, ma'am. Can I get your full name, please?
Melanie Alexis Fenton.
Thank you, Ms. Fenton. This is the time set for your initial appearance. I'm seeing you today out of Tucson City Court for some new misdemeanor charges. They are for disorderly conduct and assault alleged to be domestic violence. Now, you
Yes.
have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. So, ma'am, today I am going to release you on your own promise. You're getting out of jail today. Conditions of your release include do not commit any acts of domestic violence, no contact with Mr. Jeremy Rose while your case is pending. Your next court date, ma'am, will be August 26th. That's in about a month or from now at 1:30 p.m. at the Tucson City Court. When you get released from
Yes.
jail this morning, ma'am, you'll get a sheet of paper with all the information. There'll also be a phone number on there. So if you can't make that date for some reason, call them and let them know to reschedule. If you don't call them, you don't show up, a warrant can issue for your arrest. Trial can go without you. If you're convicted at a trial in your absence and not able to be sentenced within 90 days due to warrant status, you may lose your right to a direct appeal. Do you understand the consequences of failing to show to court, Ms. Fenton?
I understand.
Okay, thank you, ma'am. You're excused for today.
Ms. Hayes?
All right, thank you for your patience. Can I get your full name, please? Can I get your full name, please?
Tiana Hughes.
Thank you, Ms. Hayes. This is a time set for your initial appearance. I'm seeing you out of. Hold on, ma'am. Hold on, ma'am. I will address you when it's your turn to speak. All right, Ms. Hayes, this is the time set for your initial appearance. I'm seeing you out of Tucson City Court for some new misdemeanor charges. They're for disorderly conduct, assault, and criminal trespass, which are alleged to be domestic violence. All right, Ms. Hayes, you have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. I'll be setting some release conditions for you today, ma'am. I believe Anna Delgado is on the line. Ma'am, did you want to be heard?
Yes, ma'am.
All right, go ahead.
Ana Lene Delgado.
All right, what did you want me to know, Ms. Delgado?
I was just wondering if by any chance, if you could not release her today, only because I'm in fear of my daughters. I have 2 other girls here and I'm in fear of their life. Chauncey knew that she couldn't come back to my house and she came back and she attacked us. And I would prefer if possibly she did not get released today.
And you want absolutely no contact with her at this time?
I do not, ma'am.
there anything else you wanted me to know?
She's my daughter.
All right, thank you.
And yeah, that's it.
All right, Ms. Hayes, you heard what Ms. Delgado had to say. Do you have somewhere you can stay that is not with her?
Yes.
Where would you go stay?
She's homeless.
Ms. Hayes, where
I
would you
would
go
be-
stay?
I would be staying with my boyfriend.
And where does he stay?
It's over in Ironwood.
And that's local in Pima County?
Yes.
All right, ma'am. So I am going to release you on your own promise to appear for your next court date. That means you are getting released from jail today. If you can't stay with your boyfriend for some reason outside the Pima County Jail, there's something called the Pima County Transition Center. They assist with temporary housing. Sometimes they could provide a phone for you as well. So you may want to check in there just to see if they have some resources for you, okay? You heard what your mother had to say. Do not commit any acts of domestic violence. You are to have no contact with her whatsoever. Do not go back to her house. Can you understand, ma'am? Okay. If you do have contact with her, if you go back to her house, you know what she's going to do. She's going to call the police. You're going to be violating your release conditions. You could be taken back into custody. Okay. Do you understand that, Ms. Hayes? Okay. Your next court date, ma'am, is August 22nd at 9:30 a.m. at the Tucson City Court. When you get released from jail this morning, ma'am, you'll get a sheet of paper with all the information. There's also be a phone number on there. If you can't make it to that court date, or if you don't have transportation or something, you call them and let them know in advance so you don't get a warrant out for your arrest. If you don't show up, you don't call them in advance, you can get a warrant out there, okay? If you fail to appear for court, a warrant can issue. Trial can go without you. If you're convicted at a trial in your absence but not able to be sentenced within 90 days due to warrant status, you may lose your right to a direct appeal. So it's your best interest to show up to court to get this taken care of. You understand all that, Ms. Hayes? All right, thank you. I'm going to enter not guilty pleas on your behalf. You're excused for today.
Martinez.
Morning, sir. Can I get your full name, please?
Marco Martinez.
Mr. Martinez, this is a time set for initial appearance. I'm seeing you today on some new misdemeanor charges out of Tucson City Court. They are for threatening and intimidating and disorderly conduct. Both are alleged to be domestic violence and they are misdemeanors. All right, so you have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. So, sir, today I am going to release you on your own promise to appear for your next court date. That's just a fancy way of saying you're getting out of jail today. You don't have to keep in contact with anyone other than making sure you show up to your next court date. Conditions of your release include: do not commit any acts of domestic violence, no contact with Ms. Corey Free, don't go to her house or anything like that, or her workplace. Your next court date, sir, will be August 25th at 9:30 a.m. at the Tucson City Court. When you get released from jail today, you'll get a sheet of paper with all the information. There'll also be a phone number on there. If you can't make it to that date, sir, make sure to call and reschedule. Otherwise, a warrant can issue if you don't show up. Trial can actually go without you if you're convicted at a trial in your absence, but not able to be sentenced within 90 days due to warrant status. You may lose your right to a direct appeal. Do you understand the consequences of failing to show to court, Mr. Martinez?
Yes, Your Honor, and you have my word. I'll never talk to that lady again.
Thank you. All right, you're excused for today. I'm going to enter not guilty pleas on your behalf.
Thank you.
Good morning, ma'am. Can I get your full name, please?
Yeah, your name?
Sorry, one more time, your name?
Andrea Barrett.
Thank you, Ms.
Sorry, I
Barrett.
can't talk. I've been screaming.
That's all right, thank you.
I just couldn't give me any food, water, or medical attention.
All right, good morning, ma'am. This is the time set for your initial appearance. I'm seeing you at a Tucson City Court today for a new misdemeanor charge of disorderly conduct, domestic violence. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. Ma'am, if I release you today, is there somewhere you can go that is not with Joseph?
Yes.
Where would you go stay?
Well, it's my house, so he's leaving. I have a restraining order.
Okay.
I have my own Range Rover as well, so I can go take my Range Rover and go to a hotel.
Okay. All right. Thank you. All right,
But he needs to leave the house.
All right. Well, I'm not going to, I can't order him to do anything. I can only order you to do something right now. So.
Okay. Okay. And then we'll figure it out the rest later. Okay.
I'm going to release you on your own promise to appear for your next court date. That's just a fancy way of saying I'm releasing you on this case, but it does look like you have a Title 36 hold, so you'll have to figure that out first. All right. Conditions of your release.
I'm sorry. Can you explain what a Title 36 hold is?
It's regarding mental health. All right.
Can you tell me any more?
I really can't tell you any more of that. The jail should be able to give you more information about that.
Okay.
Something besides me. All right.
Okay.
Conditions of your release include do not commit any acts of domestic violence, no contact with Mr. Casertano. You have to have a separate residence from him while your case is ongoing. You can go back to your house one time with police escort to pick up your personal belongings before you find. Okay. All right. Your next court date for Tucson City will be August 26th at 1:30 p.m. When you get released from jail today, you'll get a sheet of paper with all the, or I don't know if it's today, but when you get released from jail, you get a sheet of paper with the information. If you fail to appear for court, ma'am, a warrant can issue for your arrest. Trial can go without you. If you're convicted at a trial in your absence, but not able to be sentenced within 90 days due to warrant status, you may lose your right to a direct appeal. Do you understand the consequences of failing to show to court, Ms. Barrett?
I understand everything you said and I agree. Thank you very much.
And there's also going to be a phone number on there. So if you can't make that date for some reason, you call them and let them know to reschedule.
Thank you, ma'am.
I'm going to enter not guilty pleas on your behalf. You're excused, ma'am. Thank you.
Thank you, Your Honor.
Donahue.
And counsel at the jail, is that Mr. Bimani?
Yes, Judge.
Oh.
All right, good morning, sir. Can I get your full name, please?
Joshua Donahue.
Okay, so Donahue, this is the time set for initial appearance. I'm seeing you for some new felony charges, possession of narcotic drugs, possession of drug paraphernalia. Offense date is from December of 2024. You also have a failure to appear at a Tucson City Court for assault, criminal trespass, disorderly conduct, which are misdemeanors. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. In your felony case, I'll appoint the Pima County Public Defender's Office to represent you. You have an attorney seated next to you for today. I'll be setting release conditions for you, Mr. Donahue, for your felony case as well as for your misdemeanor case. We'll start with felonies first. I have reviewed the pretrial services report and the interim complaint. The state's written recommendation is a $2,500 bond and screen first steps. Mr. Poston, did you want to be heard further?
Nothing further, Your Honor.
Thank you. Mr. Bimani?
Judge, I was just gonna argue that Mr. Donahue has no prior felonies, is lifelong resident of Tucson, and considering the state wants him screened for steps, I would argue for pretrial services release.
Judge,
Yes, go ahead, Mr. Poston.
but for the extended period of time out on failure to appear, the state would have concurred, however, given the defendant's time out on warrant the recommendations for 2,500.
Oh, thank you. And like,
And Mr. Poston, which warrant are you referring to? Is it for this case?
No, the warrant here is a misdemeanor warrant and Your Honor, the state will take that back. 2,500, the state will defer to the court.
Okay, thank you. All right, Mr. Donahue, the state is saying you may be eligible to participate in a drug treatment program. Would you be interested?
Yeah.
So that treatment program is called STEPS. I'll set you a STEPS hearing for next week, July 30th at 9 a.m. That's going to be at the Pima County Superior Court. I will release you to pretrial services on your felony case. You have to keep in contact with pretrial services. They're very good about letting you know the next court date, reminding you, sending you information about where you have to show up. No drugs, no alcohol, no weapons, any monitoring treatment as directed by pretrial services. If you don't show up for that July 30th date, so they're not going to consider you for that program. So it's very important you show up. If you qualify, you participate in the program, you complete it successfully, they dismiss the felony charges. Mr. Bimani, waive time for the preliminary hearing date.
Yes, Judge.
Preliminary hearing date will be pushed to September 8th, 2025 at 1:30 p.m. So that's pushed back so that you have time to complete the program. It does look like you have a Title 36 hold right now as well, so I don't know if it'll be released today. It will be released on that case. All right, and on your Tucson City Court case matter, sir, looks like the offense date is from December of last year, and you were given a citation. So you didn't show up to a court date given on your citation, which was Christmas Eve. All right, so on that one, sir, I am going to release you on your own promise to appear for your next court date. Conditions include no contact with the alleged victims of the trespass. Don't show up to that location. It's on time. Next court date is August 25th at 9 a.m. at the Tucson City Courthouse. When you get released from custody, you'll get 2 sheets of paper. One will be about that STEPS program. Next one will be about the Tucson City Court case. All right.
All right.
Won't show up to court, sir. A warrant can issue for your arrest. Do you understand all that, Mr. Donahue?
Good.
Thank you, sir. You're excused for today. Morning, sir. Can I get your full name, please?
Richard Ernest Holtz.
Thank you, Mr. Holtz. This is the time set for your initial appearance. I'm seeing you today on some new felony charges. Vulnerable adult abuse, domestic violence, which is a felony, and also misdemeanor disorderly conduct and assault, domestic violence. Now, you have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm appointing the Pima County Public Defender's Office to represent you. You have an attorney seated next to you for today. I'll be setting release conditions for you, sir. I have reviewed the.
So I'm in here for what? I can't comprehend anything, so.
The charges are for, telling you the charges one more time. The charges are for vulnerable adult abuse, domestic violence. That is a felony.
Who'd I hit?
The alleged victim is your stepfather. That's okay. You don't have to agree with me. Disorderly conduct, domestic violence, and assault, domestic violence. You don't have to agree with anything I say, sir. I'm just telling you what the charges are. All right, I have reviewed the pretrial services report and the interim complaint. The state's written recommendation is a $50,000 bond. Mr. Poston, would you like to be heard further?
No, Your Honor.
Thank you. Mr. Bimani?
Yes, Judge. Can I get 1 second to talk to Mr. Holtz about his? Yes, Judge. All right, so Mr. Holtz is only a level 1 according to pretrial services, only a 2 on the NCA and FPA scales. While he does have priors, his only felony priors are basically drug offenses from
Don't have no felonies.
2007. We did.
I'm just letting you know I have all misdemeanors.
According to the pretrial services report, the felonies that he does have are drugs from 2007 to 2011, so very remote in time. And then the only misdemeanor I see on there, he was sentenced to probation in 2019, and that it was for a year, so presumably he finished that. He's a lifelong resident of Tucson. He is unemployed, and he would not. He is unemployed, and I don't have information about separate residence. But given his low scores and his lack of criminal history, and also some mental health concerns that counsel has noticed, and the fact that he's unemployed, I asked the court to just reduce the bond to $10,000.
All right, thank you. I did review the pretrial services report, includes 2 prior felony cases. One has been designated a misdemeanor. The other one remains undesignated, according to Agave. Okay. I will impose a bond of $10,000. It will be cash or secured, released to pretrial services if the bond is posted. So if you post that bond or if your release, conditions include: do not commit any acts of domestic violence, no drugs, no alcohol, no weapons. Any monitoring treatment is directed by pretrial, no contact with Mr. John McCoy. And if you are released, you must establish alternate housing from him. Next court date, sir, is a preliminary hearing on August 4th at 1:30 p.m. That's for a preliminary hearing. That date may or may not go forward, so please keep in contact with your public defender. If you fail to appear for court, sir, a warrant can issue for your arrest. You understand?
When was that date?
It's August 4th at 1:30. All right, you understand that if you fail to appear for
Where
court,
do,
sir, a
where
warrant
do I
can
show
issue.
up, ma'am?
That's at the Justice Court, but that date may or may not go forward, so please keep in contact with your attorney. They'll tell you if you need to show up or not.
Yeah, you'll get it.
All right, you're excused for today, Mr. Holtz. Thank you.
Thank you.
I'm sorry, Judge. What was the bond set there, just for my notes?
10,000.
Thank you.
All right, good morning, sir. Can I get your full name, please?
Gregory Rudy Aguilera.
Thank you, Mr. Aguilera. This is a time set for your initial appearance. I'm seeing you today on some new felony charges, sir. Fraudulent schemes and artifices, theft of means of transportation, and forgery. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm going to appoint the Pima County Public Defender's Office to represent you. You have an attorney seated next to you for today. I'll be setting release conditions for you, sir. I have reviewed the pretrial services report and the interim complaint. The state's written recommendation is a $5,000 bond. Mr. Poston, would you like to be heard further?
Your Honor, the recommendation is based largely on the defendant's extensive history of fraud and other fraud and forgery related convictions, and also the specific nature of the present offense, which started a theft of means of transportation and turned into several transactions that were fraudulent. The state's very concerned about this person's fraud habit.
Thank you, Mr. Poston. Mr. Bomani?
Yes, Judge. Start out, I just want to point out that this is a nonviolent offense. Mr. Aguilera's scored a level 1 by pretrial services, 3 on the NCA scale, only 2 on the FTA scale. He's full-time employed. He has lived in Tucson for a little over a year. I believe it was a year and a half, which isn't that long, admittedly, but he does have a house here, so that, shows that he has roots here and would not be a flight risk. And in regard to the priors, they're all from California, and the most recent one that I see was a conviction from 2013. The 3 that I see on the pretrial services report are from 2012, 2013, 2012. So while I understand the state's concern about his history and his priors, I just want to point out that the most recent one is at least 12 years old. And so because of that, we asked the court release Mr. Aguilera to pretrial services. Sorry, that was supposed to be a period then. Release Mr. Aguilera to pretrial services.
Thank you, Mr. Bomani. All right, Mr. Aguilera, the state is concerned about the allegations in the interim and the nature of the priors, as well as the nature of the current offense being quite similar. The court will impose a bond of $5,000 in this case. It will be cash or secured, released to pretrial services if the bond is posted. If you do post that bond, sir, or if you're released, conditions include do not drive without a valid driver's license, no drugs, no alcohol, no weapons, any monitoring treatment is directed by pretrial, absolutely no contact with the alleged victim, the owner of the vehicle. Don't try to go find her, anything like that. You must not leave Pima County without further order of the court. Next court date is August 4th at 1:30 p.m. for a preliminary hearing. That date may or may not go forward, sir, so please keep in contact with your attorney, the public defender. If you fail to appear for court, whether it's that date or a future date, a warrant can issue for your arrest. You understand all that, Mr. Aguilera?
Yes.
Thank you, sir. Your excuse for today.
Mr. Alachoa?
Good morning, sir. Can I get your full name, please?
Michael Allen Ochoa.
Thank you, Mr. Alan Ochoa. This is the time set for your initial appearance. I'm seeing today on some new felony charges: possession of a weapon by prohibited possessor, possession of a defaced weapon, and defacing a deadly weapon. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm appointing the Pima County Public Defender's Office to represent you, and even an attorney seated next to you for today. I'll be setting some release conditions for you, Mr. Alan Ochoa. I have reviewed the pretrial services report and the interim complaint. The state's written recommendation is a $50,000 bond. Mr. Poston, would the state like to be heard further?
Your Honor, this defendant already has convictions for burglary and ag assault with a deadly weapon. He's found his vehicle was parked in a county park after dark, and the police, after investigating, were approached by this defendant. He admitted possession of a Glock in the vehicle, as well as magazines and ammunition. He's a prohibited possessor, and he has a Glock with a defaced serial number. He's already got violent gun crimes in his past, and he has allegedly been found in possession of yet another firearm, and not just another firearm, but a firearm with a defaced serial number. Your Honor, this person is a danger to the community. He's a prohibited possessor with weapons. $50,000.
All right, thank you. Mr. Bomani?
Yes, Judge. I want to start out by challenging the probable cause in this case. So, Mr. Alan Ochoa did not admit to having a gun, nor did police find a gun in his car or in his backpack or on his person or anywhere in his possession. Where they found the gun was by the bathrooms at Brandy Fenton Park. What they did find on him was, or in his car, so in his possession, was magazines, a few magazines with bullets. And that is not enough to amount to prohibited possession. Prohibited possession. All of these charges basically have to do with deadly weapons, and a deadly weapon is one that can actually fire something. It's not simply a magazine. So based on those reasons and the fact that the interim complaint does not establish that Mr. Alachoa had possession of the Glock that they found, we ask the court to find that there's no probable cause on this case.
All right, thank you. Mr. Poston, did you want to be heard on the probable cause argument?
Let me bring up the IC one more time, one moment. Three loaded magazines with 9mm hollow point rounds are found, which is consistent with the brown Glock 48 that was found near the restroom. The defendant, without being asked, was searched, and a 9mm pistol, the weapon was consistent with the ammunition as well as the magazines that were found. There was probable cause based on the fact that it was a consent search, and the presence of these magazines in the same area as the defendant, who was apparently the only person the officer interacted with, it's far too much of a coincidence that there were several magazines that were compatible with the weapon that was found, and defendant's statements that he keeps magazines with bullets because, quote, in this neighborhood people like to take stuff, so he keeps it to, quote, intimidate people, unquote. The state's at a loss to figure out how a magazine with rounds in it somehow is intimidating. It's an absolutely useless item without the weapon that chambers and fires the ammo coming from those mags. There's probable cause here, Your Honor. It's stretching it to try to say that the defendant cannot be tied to this weapon.
All right, thank you. The court does find that, based on the information in the interim complaint, that Mr. Alachoa had constructive possession of the weapons, and the state's argument regarding the bullets being consistent with the type of rounds that were found with the Glock is also persuasive. I do find that there's probable cause to move forward at this juncture. The court will impose a bond of $2,500. It will. Sorry, Mr. Bomani, did you want to be heard?
Yes, Judge, just briefly. On the conditions of release, I just want to point out that Mr. Alachoa, while he does have the history, was not on probation or anything of the like. He was paroled in 2023 and was able to finish his term of parole successfully last year. He's a lifelong resident of Tucson. He's been at the same address for 26 years. He wouldn't be a flight risk. And he is also a full-time college student. And so being in custody, would serve as an impediment to him trying to progress and move past, his history, his criminal history. And given those reasons, we ask Mr. Alachoa be released to pretrial services, or the alternative, set a lower bond at $1,000.
Thank you. I'm sorry, I skipped over Ms. Bomani. Thank you for reminding me.
That's okay.
Mr. Alachoa, I'm going to impose a bond of $1,000. It will be cash or secured, released to pretrial services if the bond is posted. If you do post that bond, or if you're released, there are absolutely no weapons, no ammo, no nothing, okay? No drugs, no alcohol. Any monitoring treatment is directed by pretrial. Your next court date, sir, will be August 4th at 1:30 p.m. for a preliminary hearing. That date may or may not go forward, so please keep in contact with your attorney, the public defender. If you fail to appear for court, whether it's at August 4th date or a future date, a warrant can issue for your arrest. You understand all that, sir?
Yes.
All right, thank you, Mr. Alachoa. You're released for, or you're excused for today.
Okay.
Bermudez. Bermudez.
All right, good morning, sir. Can I get your full name, please?
Martin Javier Bermudez.
Thank you, Mr. Bermudez. This is the time set for your initial appearance. I'm seeing you for some new felony charges today for 4 counts of aggravated assault on a peace officer, criminal damage, disorderly conduct, and assault, which are misdemeanors. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm going to appoint the Pima County Public Defender's Office to represent you. And you have an attorney seated next to you for purpose of today. The jail's indicating there's also a DNA hold on you, which means they're going to get some buccal swabs before any release from custody. All right, so I'll be setting release conditions for you. I have reviewed the pretrial services report and the interim complaint. The state's written recommendation is $7,500. Mr. Poston, would you like to be heard further?
No, Your Honor.
Thank you. Mr. Bimani?
Yes, Judge. Give me 1 moment, please.
Okay.
Okay. So, Judge, Mr. Bermudez has scored only a level 1 by pretrial services, 2 on the NCA scale, 3 on the FTA scale. Per his report, he doesn't have any prior felonies or any felony history. He is only 26 years old. He's a lifelong resident of Tucson. While he is unemployed, according to the report, his mom would be willing to take third-party custody of him, and I'm not sure if that's this. Does your mom live with you, or is she at his different? Okay. So his mom lives at a different address. He's been living at the same address for a number of years. So he would have, 2 places to go. Obviously, those would be away from the victims, considering they're peace officers. And I understand the nature of the charges, but just based on reading the interim complaint, it seems like this was, very clearly a mental health episode. And, given the other factors that I just mentioned, we asked Mr. Bermudez be released to pretrial services, or in the alternative, have a lower bond at $2,500.
All right, thank you. The court is concerned about the allegations in the interim complaint. The court will impose a bond of $5,000. It will be cash or secured, released to pretrial services if the bond is posted. If you post that bond, sir, if your release conditions include no drugs, no alcohol, no weapons, any monitoring treatment is directed by pretrial, not initiate contact with any of the alleged officer victims, do not return to the incident location, which is Johann Sproul's residence. Your next court date, sir, was a preliminary hearing on August 4th at 1:30 p.m. That date may or may not go forward, so please keep in contact with your attorney, the public defender. If you fail to appear for court, sir, whether it's that date or a future date, a warrant can issue for your arrest. You understand all that, Mr. Bermudez?
Yes.
All right, thank you, sir. You're excused for today.
Dixon.
All right, good morning, ma'am. Can I get your full name, please?
Sabrina Jasmine Dixon.
Thank you, Ms. Dixon. This is the time set for your initial appearance. I'm seeing today on a felony charge for aggravated assault with a deadly weapon on a peace officer. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm going to appoint the Pima County Public Defender's Office to represent you, and you have an attorney seated next to you for today. I'll be setting some release conditions for you, ma'am. I have reviewed the pretrial services report and the interim complaint. The state's written recommendation is a $15,000 bond. Mr. Poston, would you like to be heard further?
Your Honor, this person is accused of having pointed absolutely unprovokedly, pointing a gun at a deputy who was just trying to see why a person was walking in the middle of the night, waving something in the air. This could have ended very poorly. Folks that aim weapons at deputies tend to not have a good outcome on this. 15,000.
Thank you. Mr. Bimani?
Yes, Judge. Actually, can you give me 1 second to talk to Dixon? All right. So, Judge, I understand the nature of the allegations in the interim complaint, but Ms. Dixon was listed only a level 1 by pretrial services, 1 on the NCA scale, only a 2 on the FTA scale, but I only see that she has it all it says is a failure to appear older than 2 years ago. That's the only information, so I think that's the only reason that it would be more than that, more than the 1. She lives with her kids and her husband in Tucson. She's been in Tucson for 20 years, so she has significant roots here. She has no criminal history at all. I don't see any felonies or misdemeanors on the pretrial services report, and she is not employed because she is a stay-at-home mom. Her husband works full-time as a truck driver, and how many kids do you have? And she has 3 kids who she stays at home and takes care of. If she were to stay in custody, that would, put a huge burden on both her kids and her husband and her family as a whole. And so, given her home situation, the fact that she would not be a flight risk, and the lack of criminal history, we asked the court to release Ms. Dixon to pretrial services, or the alternative, set a bond that would be significantly less onerous, somewhere around the $2,500.
All right, thank you. The court is concerned that a mother of 3 children be out at night at 11 p.m. with the allegations in the interim occurring. The court does believe a bond is appropriate given the allegations of this offense and the alleged offense involving a weapon. The court will impose a bond of $10,000. It will be cash or secured, released to pretrial services if the bond is posted. And if you don't post that bond, or if you're released, conditions include absolutely no weapons whatsoever, no magazines, no bullets, nothing. No drugs, no alcohol. Any monitoring treatment is directed by pretrial. No contact with the alleged officer victim. Your next court date, ma'am, will be August 4th at 1:30 p.m. for a preliminary hearing. That date may or may not go forward, so please keep in contact with your attorney, the public defender. If you fail to appear for court, whether it's that date or a future date, a warrant can issue for your arrest. Do you understand all that, Ms. Dixon?
Yes.
All right, thank you, ma'am. You're excused for today.
Drafton.
Good morning, ma'am. Can I get your full name, please?
Monique Renee Drafton.
Ms. Drafton, this is the time set for your initial appearance. I'm seeing you today for a fugitive warrant out of California for failure to comply, obstruction of a court order. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm appointing the Pima County Legal Defender's Office to represent you, and you have an attorney seated next to you for today. I'll be setting some release conditions for you, ma'am. I have reviewed the pretrial services report and the interim complaint. The state's requesting a no bond hold. Mr. Poston, is that correct?
Your Honor, the California warrant would indicate no bond.
All right, thank you. Mr. Bimani?
Can you give me 1 second, Judge? All right. Thank you, Judge. Well, first, I just want to mention that in the interim complaints that we received, the one for Miss Drafton, the statement of probable cause about, all of this. I understand that there's the warrant that's attached, but it doesn't say her name at all in the probable cause statement. And so I guess I'm challenging probable cause.
All right, folks, I'm just speaking to the officer here, and his understanding is they were both with the children. Mr. Nunn and Miss Drafton were both with the children, so he's just making the typographical error, a fix there. Okay. Okay. All right. So the officer is avowing that Miss Drafton and Mr. Nunn both have their separate warrants regarding the same California case regarding the custody of the children.
And if that's the case, I believe that the state would they have the right to ask for no bond, and so the no bond hearing would be set.
So
Your Honor, sorry.
No, go ahead, Mr. Poston.
I don't believe that's procedurally correct. There's not a no bond hearing. This is now a fugitive extradition matter. So it's a matter of we either go ahead and get the governor's warrant to extradite, or we just straight extradite on this one. But it's not a no bond hearing as if they were charged, if they were on release previous to a current charge.
Mr. Bonamani, that is my understanding as well. Typically, there are bond amounts on out-of-state warrants unless it's post-adjudication on a felony. I've not seen this before where it's a child custody type situation, but that is what it says, that the California warrant is a no bond, no bail warrant.
So just to be clear, then, would I be able to argue for a lower bond?
You're always welcome to argue for a lower bond. Like I said, typically it's post adjudication, like a probation violation, parole violation warrant for felonies where a person is held without bond on a fugitive warrant matter. I've not seen it before, so I'm not familiar with if the court must hold no bond based on California's warrant asking for no bond on this type of a situation.
Okay, so I will argue for a lower bond, and my argument is mainly based on the fact that Ms. Drafton is listed only a level 1 offender. Seems like in the court and the interim complaint, this has to do with like child custody stuff and not necessarily a criminal, or at least definitely not a violent criminal offense. She's only a 2 on the NCA scale, 3 on the FTA scale. While she doesn't have any priors according to her pretrial services report. And she has, actually, can you give me one moment, please? I'm sorry.
You're fine.
Your Honor, I have to interject here. This doesn't seem to be an issue for bond. The state of California wants this person held no bond. And I don't know that the court has discretion to do otherwise.
Mr. Poston, I'm looking at 13.356, which is what you have cited to, and it says unless the offense for which the person is charged with is an offense that is punishable by death or life imprisonment under laws of that state, or the person is alleged to have escaped from jail or prison, violated terms of post-conviction, basically, what I was explaining to Mr. Bamani earlier, probation or parole violation, the judge in this state shall admit the person arrested to bail by bond. So I don't think under that statute, the court must honor the no bond request by the other state.
Looking at this is an extradition eligible. This is an extradition. They're looking. This appears to be an NCIC warrant, and that would concern the state has here is it's not clear whether or not this person was previously admitted to bail and has fled and is considered an absconder. That said, in the alternative, the state would reluctantly recommend a $50,000 bond.
All right, thank you, Mr. Poston. Mr. Bimani, did you want to be heard further?
Yes, Judge. So, well, as I mentioned, that it seems that this warrant, I mean, even if it is a criminal warrant on paper, it seems to stem from a like family law court order. And so given that, that's wouldn't be a violent offense, obviously. And I mentioned the pretrial services levels, no priors. She also, so Ms. Drafton lives here in the area in 3 Points. She has her 2 kids with her. Her sister also lives in the area. She's explained to me that she has no problem going to California to deal with this matter there as they want her to. It seems, at least according to her, that she wasn't really served in the first place with any type of paperwork or any type of warrant. And so given that, and just this Drafton's financial situation also, she would not be able to afford a $50,000 bond. So we're asking the court, if the court's so inclined to release her to pretrial services, release the pretrial services. If the court's inclined to set a bond, we ask a bond amount of no more than $10,000.
Thank you. In lieu of the no bond request, court will impose a bond of $50,000. It will be cash, released to pretrial services if the bond is posted. No drugs, no alcohol, no weapons. Any monitoring treatment is directed by pretrial. Your next court date, ma'am, will be at the Superior Courthouse on Monday, July 28th at 2:30 p.m. That's for a fugitive warrant review hearing.
Yes, sir. How are we doing this?
That'll be all for today. Thank you, Ms. Drafton.
Judge, can I get the date and time for the
Yes, July 28th at 2:30 p.m.
2:30? And is she assigned any counsel?
The Legal Defender's Office.
Legal defender. Thank you, Judge.
You're welcome.
Good luck.
Good morning, sir. Can I get your full name, please?
Yes, Stephen Redfall.
Thank you, Mr. Funk. This is the time set for initial appearance. I'm seeing you today for some new felony charges, possession of narcotic drugs and possession of drug paraphernalia. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm going to appoint Christopher Shalepi to represent you. I'll be setting release conditions for you, sir, on this new case. I have reviewed the pretrial for services report, the interim complaint. The state's requesting a no bond hold. It does look like Mr. Funk is pending 2 CR numbers out of Pima County Superior Court and is on probation out of Maricopa County Superior Court on a separate matter. Mr. Poston, is that correct? You'd like to seek a no bond hearing? Mr. Poston?
Your Honor. It is correct. Can you hear me?
Yes, I can hear you. Thank you. And no steps for this case?
Given all of the circumstances, no steps.
All right, thank you. Mr. Bimani?
Yes, Judge. Yes, indeed. So I would like to, I understand the state asked for no bond hearing. I would like to challenge probable cause at this time if I'm able to. And the challenge stems from the fact, so Mr. Funk is charged with narcotic drug possession and drug paraphernalia. For the paraphernalia, all it says is, quote unquote numerous paraphernalia items. There's no specific, reference to any single item or anything that would count as paraphernalia under the statute. And I know I've made this argument a few times before, but the M30 pills that they found, there's nothing that there's no NIC test, there's nothing that indicate that they are fentanyl other than the probable cause statement saying there's 17 M30 fentanyl pills. It seems that in this case, the officer did not avow to their training and experience either to the fact that they're fentanyl pills. And so given both of those issues, we asked the court to find that there's no probable cause on the possession of narcotic drugs because there's not enough to show that it was fentanyl, it was the narcotic drug that they're saying it was, and it's on the paraphernalia, considering they did not point to any single item that would fall under paraphernalia.
All right, thank you, Mr. Poston.
Your Honor, the state submits on the issue of paraphernalia and on the issue of the fentanyl pills. Counsel's correct. There is no NIC test out there and they're not, police officers are not expected to test suspected fentanyl pills in the field because of the absolute dire risk to officer safety that it presents. Now, as far as the magic words of based on my training and experience, Your Honor, I don't think the lack of the word training and experience. And I'm sorry, strike that. Counsel, do you have the version that says foil with residue? Because that is on the copy.
I do not. The version I have just says search incident to arrest Stephen was in possession. Okay, sorry. I do see that it was written down in pen. Okay, so then I guess I take back my challenge on the paraphernalia, but I still, uphold my challenge on the. Well, actually, sorry, strike that. I would still like the court to find whether there's probable cause on both.
The state believes that the PC statement is sufficient on its face and submits to the court.
Thank you. The court does find probable cause for the paraphernalia. The officer has handwritten the note foil with burnt residue. That would be allegedly paraphernalia for narcotics. As to the fentanyl pills, the court will find probable cause as well, even though the officer did not use the magic words, training experience, that they believe them to be M30 fentanyl pills. And regardless, M30 pills, oxycodone would also be a narcotic drug without a valid prescription. So that would still qualify as possession of narcotic drugs. All right, Mr. Bimani, did you want to be heard on the release conditions? I believe state was still asking for no bond hearing.
Yeah, so I guess just whenever the no bond hearing says.
Okay, thank you. All right, so Mr. Funk, the state is requesting a no bond hearing, a no bond hold. When someone is pending felony charges and they get arrested on new felony charges, they can request that. It's per the Arizona Constitution. So I'll set you a no bond hearing July 28th at 2:30 p.m. That's on Monday. You'll be transported for that. And at that point, the state will either have a witness to go forward on that, provide evidence of that, or they can argue for bond. And so Mr. Shalepi should be there for you, sir. And then the preliminary hearing is on August 4th at 1:30 p.m. All right, your excuse for today, Mr. Funk. Thank you. All right, good morning, sir. Can I get your full name, please?
Right, Edward Matas III.
Thank you, Mr. Matas. This is the time set for initial appearance. I'm seeing you today on 3 separate matters. You have a new felony charge, sir, for felony shoplifting. You also have failures to appear from Pima County Justice Court for shoplifting from 2023. And we have from Tucson City Court failures to appear for shoplifting and drug paraphernalia. One is from September of last year and one is from March of this year. All right, you have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. For your felony case, I'll appoint the Pima County Public Defender's Office to represent you. I need an attorney seated next to you for today. I will be setting some release conditions for you, sir. I will talk about the felonies first. I have reviewed the pretrial services report and the interim complaint. The state's written recommendation is a $2,500 bond. Mr. Poston, would the state like to be heard further?
Your Honor.
Thank you. Mr. Bimani?
Yes, Judge. So Mr. Matos is lifelong resident of Tucson. He has the support of his mom, who I believe he lives with. Lives with his mom. He's lived at the same address his whole life. And he is currently unemployed, and so even a $2,500 bond would be onerous. So I would ask for release to pretrial services. I understand if the court does want to set a bond. In that case, we would ask for a bond of no more than $500.
All right, Mr. Matos, if I release you, are you going to show up to court?
Yes, ma'am. If I could say this, the only time that why I haven't showed up is because I had trouble finding the Justice Court building. As funny as that is, but that's pretty much the only reason why.
Okay. So I'm going to take a chance on you. I'm going to release your pretrial services on your felony case. You have to keep in contact with pretrial services as often as they tell you to. There should be a window that you check in with them before you get released from jail. If you don't keep in contact with them, the next judge will find out about it. Another warrant can issue for your arrest. You don't want to be going in and out, okay? Keep in contact with pretrial. Make sure you show up to your next court date. No drugs, no alcohol, no weapons. Monitoring treatment is directed by pretrial. No contact with the business Walgreens on Valencia. Don't go back there. Next court date for your felony case is August 12th at 1:30 p.m. for preliminary hearing. That date may or may not go forward, so please keep in contact with your attorney, the public defender's office. For your justice court case, sir, I'm going to release you on that one on your own promise to appear, so you don't have to keep in contact with anyone. No one's going to be checking up on you, but you have to show up to court on that one too. No contact with the business victim of the shoplifting for that one. Next court date is August 13th at 10:30 a.m. at the Pima County Justice Court. And then for Tucson City, sir, looks like you had received citations last year and this year, but didn't show up after you got the citations. So again, citation doesn't mean you get cited and released. You have to show up to your next court date, Tucson City. So that one I'm releasing you on your own promise to appear again. No drugs, no alcohol. Don't go back to the Coles on Pantano or the Fries on Valencia. Next court date is August 25th at 9 a.m. at the Tucson City Court. It's about a month from now. As you can see, when you fail to appear for court, warrants can issue for your arrest. When you get released from jail today, you'll get 3 sheets of paper. One will be about the felony case. You have an attorney on that one. One will be about Justice Court and won't be Tucson City. I'll have the address on there and a phone number. If you can't find the location, you can't make it that day, you don't have transportation, you call that number, you let them know. Otherwise, the warrant can issue. Understand, sir?
Yes, ma'am.
Okay. Your excuse
Thank
for today.
Thank you so much.
Emmanuel.
Morning, sir. Can I get your full name, please?
Manuel Marquez.
Thank you, Mr. Nicodes. This is a time set for initial appearance. I'm seeing you today on some new felony charges: possession of narcotic drugs, possession of dangerous drugs, possession of drug paraphernalia. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm going to appoint the Pima County Public Defender's Office to represent you, and you have an attorney seated next to you for today. I'll be setting some release conditions for you, sir. I have reviewed the pretrial services report of the interim complaint. State's written recommendation is released to pretrial and screened for steps. Mr. Poston, is that correct?
Your Honor.
Thank you. Mr. Bimani?
Yes, Judge, we'll concur with that and waive time for the preliminary hearing.
Thank you. Mr. Mukaras, the state is saying you may be eligible for a drug treatment program. Would you be interested?
Yes.
Okay. So that drug treatment program is called STEPS. They'll do a screening to see if you qualify. I'll set you a STEPS hearing for next Wednesday, July 30th at 9 a.m. at the Superior Courthouse. I'm going to release you to pretrial services. They'll keep in contact with you, letting you know which courtroom to be in, what time and all that. And if you qualify for the program, you participate in it, you complete the program successfully, all the treatment, they dismiss the felony charges. So it's very important you show up, sir. If you don't show up, they're not going to consider you for the program. But I've heard it's a good program if you do participate in it. All right, release to pretrial services means no drugs, no alcohol, no weapons, any monitoring treatment as directed by pretrial. The preliminary hearing date is pushed back to September 8th at 1:30, sir, so it gives you time to participate in the program if you choose to do so. If you fail to appear for court, sir, a warrant can issue for your arrest. You understand all
Yes,
that, Mr.
ma'am.
Mokratis?
Yes, ma'am.
Thank you, sir. You're excused for today.
Naidu.
Good afternoon, sir. Can I get your full, or good morning, sir. Can I get your full name, please?
Jeremy Tomas Naidu.
Thank you, Mr. Naidu. This is a time set for initial appearance. I'm seeing you on a fugitive warrant matter out of California. Looks like it is for a probation violation for a stolen vehicle charge. All right, you have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney and appoint the Pima County Legal Defender's Office to represent you, and you have an attorney seated next to you for purpose of today. Excuse me, it looks like it's a parole violation. Hold on.
I'm sorry, Your Honor, you threw him that. I'm confused. Which individual are we discussing?
Mr. Naidu.
Okay.
So I was trying to determine if it was a parole violation or probation violation. Well, regardless, I believe it's a probation or a parole violation warrant. Okay.
I see a probation violation warrant out of Los Angeles County, California.
Okay, probation violation. All right. All right, I'll be setting release conditions for you, sir. Have reviewed the pretrial services report, the interim complaint, which includes the copy of the warrant, and the state's written recommendation, which is hold no bond due to being a probation violation. Is that correct, Mr. Poston?
Your Honor.
Mr. Bimani?
Is this I just want to clarify because this is all new to me on the fugitive stuff. So is this similar to the previous fugitive warrant?
It's
like
similar, it's similar to the fugitive, meaning it's out of state, the different states warrant, but this one appears to be post adjudication. Is what I'm seeing.
Okay. So in this case, the no bond hearing would be set, correct?
No, so
No.
for these, there is no
Okay.
bond hearing.
Okay, sorry. Okay, so Mr. Naidu, I'm not exactly sure what the current, the warrant's for, but according to pretrial services, it's nonviolent offense. He's only a level 1, only a 2 on the FTA scale. I understand that the warrant or order, one of those says that there's a parole violation. Mr. Naidu's telling me that he already got picked up on that and served his time to kill the number to finish his parole. And so, per his knowledge, he was done with parole and not, he didn't even know that, there was a warrant out or anything. He lives with his mom. And he lives with his mom here in town. If he does need to go to, seems like LA County to deal with this case, he'd be more than willing to do that. So we'd ask the court to give him the opportunity to do that out of custody. And so we asked release to pretrial services, in the alternative, setting a bond at no more than $5,000 given the circumstances of the warrant.
Thank you. I'm just reviewing the pretrial services report again. It does allege that the offense for which this warrant came out of allegedly occurred March of this year. And it resulted from an arrest that occurred in January of this year while Mr. Naidu was under parole supervision in Los Angeles County. And the warrant itself lists it's from probation department in Los Angeles County. So based on that information, the court will find that it's a post adjudication matter, that it's not a new felony offense. So the court does believe at this time that the no bond is appropriate. Mr. Naidu, I will hold you without bond at this time. I'll set a fugitive warrant hearing on July 2:30 p.m. You'll be transported for that hearing. You'll have an attorney there, and hopefully they'll have more information about the Los Angeles warrant by then. All right, you're excused for today. Thank you.
All right, thank you. Good luck.
Mr. Nunn?
What's your full name, please?
Lowercase Kyle Nunn.
Middle name Lee?
Yes.
All right, thank you, Mr. Nunn. This is the time set for initial appearance. I'm seeing you for a fugitive warrant out of California for obstruction, failure to comply with a court order regarding your children. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm appointing the Pima County Public Defender's Office to represent you, and you have an attorney seated next to you for purpose of today. I'll be setting some release conditions for you, sir. I have reviewed the pretrial services report and the interim complaint. Mr. Poston, the state's written recommendation was a no bond hold. Is that still correct?
This is the other, these are companion cases. State makes the same argument and asks the court set the same bond.
All right, thank you. And that other bond for Ms. Drafton was $50,000. Mr. Bimani?
Yes, Judge. Notwithstanding the bond in the other half of this case, I want to point out that pretrial services deemed Mr. Nunn as only a level 2 offender, 3 on the NCA and FTA scales. He has also told me that, he wasn't contacted at all in regard to the order. It seems like a family law, non-criminal order that is, where the warrant itself stems from. Furthermore, Mr. Nunn has informed me that, and I believe, let me see if it's in. I don't see in the pretrial report, but Mr. Nunn has informed me that he's disabled. That's why he's unemployed, and so $50,000 bond amount would be onerous on him. With him and his co-defendant, they're a single income household, and so it would essentially be setting a $100,000 bond on the same income that they both rely on and their children rely on. And finally, Mr. Nunn has numerous health conditions that he takes a lot of medication for, and his medication is obviously all outside of the jail, and so any possibility of release would help him work through the symptoms of his numerous conditions that are the reason why he's on disability status. And so given those factors, we ask Mr. Nunn be released to pretrial services, and the alternative, having the court consider setting a bond of no more than $10,000.
All right, thank you. The court will note regarding the children that it appears based on the California order, Mr. Nunn was not supposed to have custody of the children. So that is the underlying reason for why the absconder status or the failure to comply has arisen out of California. So,
Your Honor, the state would just renew its objection and renew its overall position that it states belief based on all the available information that California is asking these folks to be held on no bond. But in the alternative, again, state reluctantly would say 50,000.
all right, thank you. And I understand that is California's position, but I do not know that Arizona law requires us to hold someone no bond just because they require it, just based on the statutes we were just looking at. All right. The court will impose a bond of $50,000 in this matter. It will be cash, released to pretrial services if the bond is posted. So if you are released or you post the bond, no drugs, no alcohol, no weapons, no any monitoring treatment is directed by pretrial services. I'll set a fugitive warrant review hearing July 28th at 2:30. That's that Monday, sir, in the afternoon. You'll be transported for that hearing. Your attorney will be there, and you'll find out more information then. All right, thank you, Mr. Nunn. You're excused for today.
Mr. Rose, please go ahead.
Morning, sir. Can I get your full name, please?
Jeremy Russell Rose.
Thank you, Mr. Rose. This is the time set for initial appearance. I'm seeing you today on a post-indictment matter in Pima County Superior Court, CR 2024-1645. The charges for possession of dangerous drugs, possession of drug paraphernalia. Offense date is from February of 2024. And sir, I'm also seeing you for an out-of-county warrant from Yavapai County Superior Court case number for a child support violation. I'm failing to pay child support. All right, you have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney, appoint the Pima County Legal Defender's Office to represent you, and you have an attorney seated next to you for purpose of today. I'll be setting some release conditions for you, sir. I have reviewed the pretrial services report. There is no interim complaint. The original warrant amount was $500 for failing to appear in an arraignment. The state's written recommendation is $2,500. Mr. Poston, would you like to be heard further?
Your Honor, this is given the failures to appear and looking at it's a 3 out of 3 twice over, 3 out of 6 twice over, and it's not entirely. Hold on. State submits on the written recommendations.
All right, thank you. Mr. Bimani?
Yes, Judge. In regard to the failure to appear, I understand that it was for his arraignment. Mr. Rose has told me that he did not know about his arraignment date, which would track based on the fact that the notice of indictment was mailed to an address that he does not live at anymore. And so given the fact that the underlying charges are for drugs that I believe I assume he was released to pretrial to at his initial appearance on that. given all of those reasons, we ask the court to release Mr. Rose to pretrial services, or in the alternative, set a bond amount no higher than the warrant amount of $500.
All right, thank you, Mr. Bimani. So court does note from pretrial services report that Mr. Rose was released to pretrial services back in February of last year. He was enrolled in steps, terminated from steps unsatisfactorily, and it also states he failed to keep in contact with pretrial services. So regardless of whether he received the arraignment information, he should have been in contact with pretrial services. So the court will impose a bond of $500. That's the amount on the warrant. He'll be cash or secured, released to pretrial services if the bond is posted. So if you do post that bond, if you're released, you have to keep in contact with pretrial services. That they keep you in contact with all your future court dates, and also they tell you they tell the judge what's going on with you. Okay, so if you don't keep in contact with them, the judge will be like, okay, well, I'm taken back into custody then. All right, no drugs, no alcohol, sir, no weapons. Any monitoring treatment is directed by pretrial. Your next court date is arraignment, July 30th at 1:30 p.m. That's next week. As you can see, when you fail to appear for court, a warrant can issue for your arrest.
Yes, ma'am.
Then, thank you. And your other matters, sir, the out-of-county warrant for child support, family to pay child support, that warrant amount from Yavapai County is $1,500. So the court will honor that other county's warrant amount. Be $1,500, cash or secured.
That'd be, so then $2,000 altogether for the two.
Yes, and I'll set you, you're welcome to pay that bond as well. I'll set a review hearing August 25th at 9 a.m. So basically that just tracks your other case. So if you pay the bond, then you don't have to show up to the next court date here. You would just call Yavapai County and set up a new court date in Yavapai.
Your Honor, the Yavapai has to be a cash bond as a child support.
Oh, okay, my apologies. It's cash on the Yavapai warrant.
So what would be my total, like, cash, on every, for both? Just two.
I'll explain it.
Okay.
Judge.
All right, thank you. All right, good morning, sir. Can I get your full name, please?
Austin James Seagris.
Mr. Seagris, this is a time set for your initial appearance. I'm seeing you today on a new felony charge, sir, for trafficking in stolen property, which is a felony. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire your own attorney. I'm going to appoint Mark Resnick to represent you. And I'll be setting some release conditions for you today, sir. I'm sorry. And you have counsel seated next to you for today as well. I'll be setting some release conditions. I have reviewed the pretrial services report and the interim complaint. The state's written recommendation is a $7,500 bond. Mr. Poston, would you like to be heard further?
No, Your Honor.
Thank you. Mr. Bimani?
Yes, Judge. Can you give me one moment, please?
Yes.
All right. Judge, Mr. Seagris, well, first of all, this is a nonviolent offense. Mr. Seagris was listed as only a level 2 on pretrial services, 3 on both the NCA and FTA scales. He's a lifelong resident of Tucson. He does have family friends that live in the area. In fact, the first he has is a family friend whom he lives with. He's full-time employed. He's self-employed as a landscaper and a roofer. But despite being full-time employed, $7,500 would still be a lot for him to afford as a bond. I understand that he has priors, but this is a non-violent offense. As of right now, just based on the interim complaint, he wasn't even charged with the actual theft, just traffic of stolen property. And so given those factors, we asked the court to release Mr. Seagris to pretrial services. He also has been, so he's been in substance abuse treatment, and he wants to continue that, and so he would need to be out of custody for that. So we asked to release the pretrial services in the alternative, setting a less onerous bond of no more than $1,000.
Your Honor, is he on probation? Is there a probation? It would appear he is on probation. Is there a probation hold?
We just got one. This. Your Honor, our records here at the jail indicate that he does have a probation hold.
He does have a probation hold?
Yes, Your Honor.
Okay, thank you.
Well, then, Judge, just real quick, given the fact that he has a probation hold, we asked for a nominal bond amount of either $500, no more than $500.
All right, thank you. The court will impose a bond of $2,500. In this case, will be cash or secured. Release to pretrial services if bond is posted. No drugs, no alcohol, no weapons. Any monitoring treatment is directed by pretrial. No contact with the alleged business victim, the PJ Tour Superstore on Oracle. Sir, you'll see a different judge in Superior Court regarding the probation hold on a petition to revoke. If you are released on that case as well as this case, you're to contact your assigned probation officer upon your release from custody. Next court date is August 4th at 1:30 p.m. for preliminary hearing on this case. You should see your judge hopefully this week, if not early next week, on your probation case. If you fail to appear for court, a warrant can issue for your arrest. You understand all that, Mr. Seagris?
Yeah, so I'm pretty much gotta wait till my probation. I can't get enrolled into like steps or drug treatment classes or anything.
Steps is not for this type of a charge.
Okay. All right.
You're not sure.
All right. You have a good day, ma'am.
Good luck to you, sir.
So,
So I'll talk to
Right, good morning, sir. Can I get your full name, please?
Yes, then, right?
Middle name, Arthur?
Yes.
Good morning, Mr. Wright. This is the time set for your initial appearance. I'm seeing you today on some new felony charges, possession of dangerous drugs, possession of drug paraphernalia. You also have a new misdemeanor charge for driving under the influence at a Tucson City Court. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. I'm going to appoint the Office of Legal Advocate to represent you on your felony case and the Tucson City Public Defender's Office on your city court case. I'll be setting some release conditions for you, sir. We'll talk about the felonies first. I have reviewed the pretrial services report and the interim complaint. The state's written recommendation is released to pretrial screen for steps. Mr. Poston, is that correct?
Yes, Your Honor.
Thank you. Mr. Bimani?
We're good with that, and we'll waive time for the preliminary hearing.
Mr. Wright, the state is saying you may be eligible to participate in a drug treatment program for those felony charges. Are you interested, sir? Okay, so that treatment program is called STEPS. So I'll set you a STEPS hearing for next week, July 30th at 9 a.m. That's at the Superior Courthouse. You have to make sure you show up to that screening meeting, sir, because They do a screen to make sure you qualify, and you'll find out that day. If you don't show up, they're not going to consider you for that program. So make sure you show up. I will release you to pretrial services, sir. They're very good about keeping in contact with everyone who's participating in the program who might be eligible, and they'll give you the courtroom number, the time, all that stuff. No drugs, no alcohol, no weapons, any monitoring treatment as pretrial directs you to. Make sure you show up next week. The preliminary hearing date is pushed back to September 8th at 1:30, sir, and that's because it gives you time to participate in that program. If you do participate, you complete it successfully, they will dismiss those felony charges. All right. Now, in your city court case, sir, I'm going to release you on your own promise to appear for your next court date. That's just a fancy way of saying you don't have to check in with anyone other than making sure you show up to court. Do not drive without a valid driver's license. No drugs, no alcohol while your case is pending. Like I said, I'm appointing you an attorney at the Tucson City Public Defender. Next court date for that is August 25th at 9 a.m. So that's about a month from now. When you get released from jail, sir, you'll get 2 sheets of paper. You'll get one on the steps case and one on this one, the DUI on the Tucson City. They'll have phone numbers, addresses, all the things, your next court dates. If you fail to appear for court, a warrant can issue for your arrest. Trial can go without you. If you're convicted at a trial in your absence, but you're not able to be sentenced within 90 days due to warrant status, you may lose your right to a direct appeal. You understand the consequences of failing to show to court, Mr. Wright?
Yes.
All right, thank you. I'm going to enter not guilty pleas on your behalf, sir. You're excused for today.
Go on with it. Joy.
I think that was everyone. Thank you, Mr. Poston. Thank you, Mr. Pimani.
Thank you, Judge.